Hello, everyone. Good evening. Data subject rights we know is one of the fundamental elements of any privacy law. Today, we will listen to Mr. Anselm Pinto, who will not just elaborate on the data subject rights, he's also going to share the best practices in handling the data subject request. Mr. Anselm Pinto has a rich and diverse experience in various facets of compliance, risk, legal, and governance. He holds a post-graduation in corporate law, is a fellow company secretary from the Institute of Company Secretaries of India, and also holds various prestigious certifications in privacy management. He is presently looking after the compliance function of First Advantage for the Northern Asia Pacific region based out of Bangalore. His past stints include those in Amicorp Group and ICICI Venture. Over to you, Mr. Ansler.
Thank you, Manju, and thank you, FDP-API, for giving me this opportunity to present this session on data subject rights and handling requests. So just to give you a brief about the agenda, this is what we intend to cover today. We're talking about who is a data subject and why are rights being given to them. What are some of the common data subject rights? And also the handling of data subject rights request. What are some of the best practices? So while I have been trying to cover the data subject rights and handling requests from a global perspective. I have also taken material from the ISO website to really look at how we can choose from a more practical application. The handling of such requests has to be seen from an organization's perspective, and both as a controller as well as a processor. I have to try to call out some of the best practices as I could visualize based on my past experience, as well as readings from the internet. They are no account ready to use, but have to be customized for each organization based on their number of requests received. So moving to the first item which I want to cover is who is a data subject. It is important to first understand who the rights are available to. The definition of data subject is required to be understood for this purpose. Most of you, being privacy professionals, would understand the meaning of data subject, but I have all the same given the definition to you to review before we continue with this presentation. As you see, the definition of data subject relates to a person who can be identified from the data available within an organization. Another important point to note is that organizations which are global in nature, there could be reasons to hire employees who have, from different countries, or who have online customers who are residents of different countries abroad. If the data privacy law of the country where the data subject is resident has extraterritorial jurisdiction, then the processing of data, even in another country, the laws applicable to such individual would have to be complied with by the controller or processor in the processing country. So it's not necessary that just looking at one country laws you can be satisfied with. You have to go be aware of other countries' data privacy laws when it manages two things. One is, I look at it as these data subject rights, as well as also breach notifications. Both are important to have the resident of the data subject who is important from the applicable data law perspective. So another important aspect is that, as we know, data subject is not only your data that you have. The data could be even somebody from your employees, your own employees, and obviously as a controller, you will be the controller for that data. But also prospective employees who you have, maybe people who come to apply for a job or who are being considered for as candidates for a job. Also, people who visit your office are considered as data subjects. So they all have the rights that we will talk about in this particular presentation. Yeah. Why why data subject rights? I mean, basically, you'll be asking, why do we need to give these rights to a data subject? I mean, we are taking, so there are so many requirements which are already being put onto an organization in terms of security and privacy by design, privacy by default. Why are we even looking at giving data subjects some rights? So one of the things that we really to really give you the rationale is that the focus is on two things. One is on transparency and also of ensuring accuracy of data. And when you say transparency, because the data subject has a right to know how his data is being handled. It's after all he is the data, his data. He has to be given the certain controls that he has to, I would say, autonomy that comes upon him to be so that he knows where his data is, how it is being processed, and where does it travel in terms of being for the purpose of processing. So that's the reason why these rights are given to a data subject. Moving on to the next slide. So I will talk about the common data subject rights available globally. This has to be examined from each country's perspective and will necessarily vary depending upon the privacy law applicable to that country. The requirements of the law are generally I'm sorry, the rights are available. Uh, the common ones are very common ones, which I'll talk about now, is access and dispute are available in most laws. But some of the other new laws which have come in starting with GDPR and other new laws of PIPL China, they have given up more of the new rights which have also been provided there. So we'll see. I'm covering all of them, but the focus will be mainly on, because of it, I'm looking at GDPR as a benchmark. So some of these, much of the material has been taken from GDPR. So the first right which I am covering is the right to be informed, which basically, as the name suggests, provides a right to the data subject to be informed of certain aspects relating to collection and use of his personal data, his or her personal data. Again, the requirement of what has to be informed will change from country to country based on the applicable data privacy law. The implementation of this right is either done by providing information through the privacy policy, which can be located on the website of the controller or the processor, or alternatively, the information could also be provided through a notice, which can be acknowledged along with the consent taken to start a processing of data. I have also provided some instances of what information is required to be provided from countries like on UK GDPR, China PIPL, and the Brazil privacy law, and Korea too. But this is more like an indication to you of what information they're all most going towards the path that you need data subject needs to know how his data is being processed and different nuances of his data. So it varies from the country to country, but essentially it goes to our basic principle that of the transparency, where you need to know what the as an autonomy of the data subject to how his data is being processed. So this right is right to be informed is provided by most countries in some form or the other. I'll move to the next slide. If please stop me if you'd like any questions, but I'm not reading out from the slide because I assume that it's visible and anybody can, read it as we go by. But I'll answer questions later on also if required. But in between, if anybody wants to stop, please let me know. So I'll move to the next slide. So the next slide is right to access data. Now, this is it's a common right. I mean, it's there in most countries, including India, where data subject has a right to his data. And the requirement is that you can get a copy of what data an organization holds about you provided to you. That's the basic requirement, and it's pure and simple. You have to just give all the data that you have of an individual when he asks for it. That is the requirement. There's not too much of ifs and buts. The only, I would say, exclusion is when it is legally withheld by law, or there's you can't, obviously, if it's tagged along with some other individual's data, obviously you have to only give that person's data. You can't give another individual's data along with that, and that is something which you have to be very careful about, because sometimes these other individual data can creep in, and you could be exposed to a breach by providing somebody else's data when allowing an access to for a particular right, this particular right. So to be careful that you have to redact or mask all the other person's data before you provide it uh, to a data subject. Moving on to the next slide. This is the right to dispute or to correct data. Again, it's very much linked to the controller's obligation for the accuracy that the controller has to ensure accuracy of the data that he holds. And one of the ways to ensure accuracy is by allowing the data subject to correct his data or even to dispute his data. And when you say dispute, it means that the data subject can counter you and say the data that you hold of me is incorrect, or the result of data that you have, or which the processing of it of the data that you have done has been done incorrectly, and you could be asked to rectify that. So dispute, correct, rectify are all rights that the individual data subject has when his data is being held or processed by a particular organization as a controller or as a processor. So the important part to consider here is that when you what extent can you correct the data, and the data, if there was a mistake, obviously the correct information has to be provided, has to be included in the data subject's data within the organization. If an opinion is sought to be corrected, obviously you can't change somebody else's opinion, so that it'll be difficult to change that. On the other side, that if the data that you have corrected, sorry, if you have if it was not, it doesn't have to be changed because you have verified it. You can obviously tell the data subject that you cannot, data will not be amended. But important part is that, so once you get the request for a correction or for a dispute, you have to re-verify with your particular source of however you got the data. It's not like you just take the data subject's request as valid and hold on to it. So for example, if he says some more data about my date of birth is incorrect, you obviously will have to ask him for certain documentation to verify that data is actually a date of birth. I mean, and then you obviously have to look at, maybe there was a result based on which the data was provided. Basis the incorrect data was arrived at, you will have to correct that result. So that's the important part, is that you should seek that the data has to be corrected, and if there's a correct a result which is incorrect, it has to be rectified at the controller's end. So I'll move to the next slide. Now, the next slide is the right to be forgotten. This right basically is the part where a data subject can request his data to be purged or deleted from an organization's records. It is not an absolute right. It is given only in certain circumstances, and that may vary from country to country. I have in my slide have put up for UK GDPR, but every other country from China PIPL to also, which allows this, has certain conditions to which it can be implemented. Such conditions relate to whether the data was required for processing and whether the contract to which the controller was required to do the processing. Then obviously you can't delete the data, because without the data you can't process or or affect the contract. So these are things which may be required under different country laws, but in essence, it means that the data subject can request his data to be deleted, and including, we have had cases for Google and all being asked to delete his data uh, using this principle, and that's how this can be used. Important part is also, when you're deleting the data, you should obviously ensure that no other individual data should be deleted. It should only apply to the individual who's requested for his information to be deleted. But if there's what we call as, you can call as a legal hold cases. Legal hold is where there is reason for by regulatory authority, or even a particular law enforcement has asked for data to be retained for maybe in pursuant to a civil or criminal case. You would be required to retain the data, and it should not be deleted. Moving on to the next slide. Now, here are some of these are the new ones which came in with GDPR. They're not really not there in many of the other countries. The new countries which are have the new data GDPR type laws are coming out with similar requirements. This is the similar rights. This is the right to object, where the data subject has a right to stop processing of his personal data in certain circumstances. It's very similar to, withdrawing consent and saying, no, please do not do anymore, continue with the processing of my data. So the right is absolute when it comes to direct marketing. In other words, if an organization is engaged in direct marketing, this an individual can object to the processing of his data for direct marketing, and that is absolute right as far as that is concerned. So there is, I've also mentioned about the data. You can also choose what type of data and what purposes that you want to object to, and that only that you can the objection would hold good only for that processing, not for if let's say there was multiple processing for the data being for which a client a data subject has data stored within an organization. The data subject can say, I only want this set of this processing can be done, but not for something else like that. So for example, if he has given for only for let's say doing his in my company setup, okay, background screening, and he's also being data has been also had for marketing purposes. He could direct marketing purposes. He could actually say, you don't do the direct marketing, but you obviously continue with processing for background screening. So that's how you can select and choose what data you would like to object from the processing on. Okay, moving on to the next slide. The right to restrict processing here. And this right is very similar to the right to object also, because they both have similar nuances. But the right to restrict processing is more like it's a temporary hold on processing, because you would like to hold on till certain things are being resolved. For example, you are disputing certain data which is held by the controller, and you want that dispute to be resolved, and you say till the time that the dispute is resolved, you restrict processing of the data. So that's how the data is the restrict processing right can be required to be fulfilled within any organization. One of the ways of the multiple ways of handling this, but the real part is that you put a hold in your internal systems to say that this nobody can access, can modify this data, or no further processing of the data. It's sort of a lock on the system's record for the candidate in your application, so that tomorrow anybody tries to modify the data, they would obviously get a notification saying that the processing of data for this candidate is restricted. If assuming there's no other reasons why you would want to continue with processing, but assume if this right is to be fulfilled, then it has to be the modification of the record within the organization has to be locked so that further processing is not done. So I'll move to the next slide. Data portability. Data portability is something again new, and is obviously there in GDPR as well as in the PIPL, which is China law, which also allows this. But basically, it allows an individual to copy or move, transfer his data from one controller to another controller, and in using technologies which would allow the data should be moved from one IT environment to another environment, so that the new IT environment, the transferee IT environment is able to get it in the same format, and use it like maybe it'll be raw data, so that they can use it within that new environment itself, without having to adjust the systems much for that. And this is the way it should be provided here. So this is as similar, I would say similar to the right to access, except for the fact that the right to access was data is being provided to the candidate. Here the data is being provided to another controller, and that the new controller will take control of the data. So most likely to use this data would be from a scenario when you move from one organization to another organization, and you want all the data from that old organization to be transferred to a new one. As an employee also, this is one way of getting that all that information that you hold from the earlier employer to move to another employer. It could be used even when there's a merger or transfer also happening, takeover happening. The customers could have their data ported to a new customer or the new organization which has taken over the company, and in the same format they would have to be transferred, provided of course the consent is taken. Yeah, any questions? I'll move to the next slide. Yeah, so this is again one of the new rights available to in GDPR, and again under PIPL China. It is a right to if there's a right to automated decision making and profiling. So I've given the definitions of at least as per the ICO, what is automated decision making and unprofiling there. It's just more for an example for you to know how what is automated decision making and profiling. While the UK GDPR just restricts controllers from making automated decisions with on profiling. Under China PIPL, they require that the data subject be given the right or an explanation of how the processing would happen. Okay, and they should have a right to accept the outcome of the processing, and they should not really, you may not really rely on the automated decision, but they may have a right to counter it, and they might have a right to say that no, I don't want an automated decision to be done. I want it to be done manually, in not using the automated configuration which may have been used. So one of the requirements here is that if you're in your organization, if you have any processes which use automated decision making profiling, then obviously you would have to comply with this particular right. So this is the last of the rights here. Again, I'll pause if anybody would like to ask any questions with relation to any of the last rights of the past rights. We will, the next part of the presentation will be about handling these rights from organization perspective. So if any questions on the rights now, otherwise we'll move to the handling part of it. Hearing none, I'll move to the next portion. Handling data subject rights and best practices. So as a controller or as a processor, you have to look at, you'll be receiving such request. And in India, of course, these kind of rights are not really known to many of our data subjects. And therefore, most organizations may or may not have receive such request. In fact, to give you an example, a couple of years ago, I had a case with an insurance company where my medical report was given as clear, but yet the insurance company rejected my insurance policies, stating that for medical reasons, they were rejecting the policy itself. So if once you've been rejected, every other insurance company, you're required to disclose that whether any policy has been, and you've been rejected for any reason. So I went back to that the insurance company, and I tried to tell them, say, the data is incorrect, because I've got a copy of the report from the medical from the diagnostic center, saying that you have a clear report and everything is cleared. And I asked them to change their decision, or even give me the reasons for the same. Admittedly, nobody answered my response or give me any response, and finally I had to just leave it there. And this is a big name; it wasn't a small time insurance company. But the short point is that even when your organizations which were supposedly having to take care of these rights were not geared up for it, and even I, as an individual who had knowledge of the rights, the systems for the other organizations were not geared up to manage my request. So this is something that we'll soon be learning, because when the Indian data privacy law comes into force, these particular rights and the management or handling of such requests would really be important to be taken care of. So moving on to the first slide. So yeah, the first part is when you get a request, you have to really, first of all, is acknowledge the request. Is important. In fact, in many countries, in CCPA, where the first requirement is that you have to acknowledge that the request has been received. So taking an example of my insurance example, where I didn't even receive an acknowledgement by the insurance company that my request for rectification was not even accepted by them. So that it just shows that they did not even had the courtesy to say that we have acknowledged your request and we're considering it or not considering it. They didn't even acknowledge it. And that's probably, again, bad handling of the request in itself. I'm talking about just around a year or 2 years ago. The second part was the identity of the requester needs to be validated. And it's important because you wouldn't want anybody coming and asking for this information for somebody else. You have to have the legal right to make that request. Or if the same individual whose data is being is a subject of the rights request, then you obviously have your identity has to be validated. There are two forms of validation of identity. One is you would take an identity document from the requester, And the second part is you ask the requester certain set of information, which could be certain past transactions which you may have done. For example, as a bank may have done, you could say, give me your last transaction, that your last debit in your account. Let me know. There's something to that effect, and that also could be one way of identifying the individual, validating the identity of the individual. So basically, once you validate the identity, then you can move on to the next steps. Now, a lot of these requests would obviously come. You have to have modes of receiving this request. One is your obviously have a mailbox on your website, or you could even have, if you're willing to accept a request by phone call, then the telephone operator of your organizations would have to be willing to be geared up for it. Though I see that very difficult in Indian context, but it is acceptable in many other countries where you can even make a verbal request, and that can be done. So the having an email address is the most common acceptable one, and you can put that website, the email address on your website. Also, which is another way of getting requests is also from social media, using of Twitter and I think Instagram, etc., can also be used to get some requests. Of course, validation of the identity and all can be followed through either following the email mode, but it is something which can be done through for social media also. Moving on, so basically the people at the front end, that is your customer care, inward mail staff, and your social media staff, should be aware of how to handle such request. I'll move on to the next slide. So who is responsible for fulfillment of request? And here is it's between the controller and the processor. Obviously, the controller is the first person who's responsible, though he may take the assistance of the processor. And the controller also has to help in validating the identity of the data subject, and he will be responsible to fulfill the request. Though if there's a contract between the processor and the controller as to who manages the request, then it's a different scenario, because it means that the controller has delegated the responsibility of handling the request to the processor. So this is a couple of, yes, the responsibility here is overall of the controller only. Moving on to the next slide. Yeah, another important part is to, once you've received a request, and since it all involves data of the data subject, you should know whether you actually possess the data of that candidate. I mean, somebody could come and say to you and say, you have my data, but you have to have certain information. You may have to have that information before you can even agree to give it to him, because you may have deleted that information as a part of your contractual arrangements with another controller, or with just as your internal policy. Under the record retention guidelines, you may have deleted the data, or you may not possess it for whatever reason, because it's not he is mistaken that you have the data. So it's important to first find out whether you actually possess the data for that particular data subject. Second part is looking at the location where the data is within the organization. Now, this can get really complicated if it is there in multiple systems, and each system may be interlinked with another third-party application, etc. So, for example, you have different applications for customers, for employees. So these tools have to be the data has to be deleted from there. And also, if you have given your data to be processed outside the organization to sub-processors, etc., in such case, they also you have to find out whether they hold the data there also. If you have done the mapping of your data or any data inventory, those exercises would help you in understanding the location of the data. But it is not always that easy. But in the Indian context, this is becoming more and more required, that you know where your data is stored, and if you have done a data inventory exercise, would be helpful. Moving on to the next slide. So the once you've validated the identity of the data requester, and you have now known where the data is located, you have to either fulfill the request or reject the request. Now, fulfilling the request or rejecting is a choice of yours, because based on the local laws, you have to decide whether the local laws allows you to reject a request. But there are common reasons for rejecting a request. One is that you cannot identify the data subject. If a data subject says, here's my name, and it happens to be a common name, but you're not able to find the name in your records, or you're not able to get a multiple, the validation is not able to be you're not able to validate the identity, because the documents provided, you don't have a way of comparing it. That could be what some of the reasons of where you have not been able to establish the identity of the data subject. And of course, GDPR allows, I'm giving example of GDPR allows certain cases which are, unfounded or excessive or repetitive in nature. Those cases can be rejected also. So this is the important part, is that you to decide whether you're going to fulfill and how you're going to fulfill the request. And this is the way, is the option that are available to you. Moving on to the next slide. So once you've fulfilled to decide to fulfill the request, you have to obviously communicate it to the data subject. And once we've already talked about acknowledgement of the request, but here is, and you may also have to keep on looking at, you have to get the identity and validate the identity for the fulfillment of the request. That's all, we already talked about that earlier. But important part is that when you communicate and you're giving personal data, you have to ensure that the data is shared through secure means. So either, for example, if you're giving a candidate access, you should send them the data using an STP protocols, or you should do a password protection and send the password in a different mail or something like that. That's something which are multiple encryption technologies that are available, should be used in sharing personal data over the internet. The whatever you Whenever you're giving the data, or any communicating with the data subject, it has to be recorded in a tracker, which I will talk about in the next slide. But it's important that to have all of these data recorded, stored with you, because all the emails, etc. Because tomorrow, if you're being asked by a regulator as to why you did not respond to a request, or whether you have not responded to a request in appropriate time, then you have this emails, and there's a tracking mechanism to show that you are watching the timelines for fulfillment of this request. This is critical to ensuring that you have proper processes in place to ensure data subject rights requests are handled properly. Moving on to the next slide. So here I talk about the standard operating procedure, or a tracker, which is necessary to ensure that all these requests are handled in a manner and recorded properly. Right now, if the requests are low, obviously you can just use a spreadsheet. But if the requests go abnormally high, and you don't have a spreadsheet may be a little difficult to manage it. So you can use an automated tool by third-party applications which are available, which allow you to communicate with the candidate, as well as provide the data in secure means, as well as track your timelines. Those tools are available, but if the number is less, obviously a simple worksheet should be fine. Again, if the number is large, you may want to get MIS for ensuring that somebody's the trends and how are you performing in terms of timelines in managing that particular request. The important part is that compliance team or the privacy teams, they should oversee this particular whole process, because if you again, if you reject a request, you forget to even respond, or you delay the response, it can lead to the consequences which I will be talking about in the next slide. But it's important that the compliance team or privacy team actually has oversight over this, so that these and they have enough of data to show that they get enough of information to see that these requests are being managed properly. Yeah. Okay. So here is every country will have different timelines for request. I've given the data from here from GDPR, but it varies from country to country. Some may also provide for a reasonable time frame, but it has to be looked at the individual country laws to decide what is the timeline, and obviously you have to abide by that. So I've also suggested that if again you're operating in a global environment with multiple countries, data subjects, you may want to keep a ready reckoner of the different countries' data subject rights and how to manage those requests, or the different requirements for those countries should be available with you as a ready reckoner, so you can manage the request accordingly. Yeah, this is the part where what would happen if a data subject rights request was not done within the time frame, or it was not done at all. These are the consequences. Again, this is largely from GDPR, but the outer limit of while some of the overall penalties which are there, I have not given that, because obviously in the overall scheme of things, a data subject right request not handled properly is not considered as a major high risk obligation or high risk failure. But I would look at it as something which can definitely reach to a regulator, and the regulator will get involved. Supervisory authority can get involved in ensuring that the request is to be complied with it. And again, if the supervisory authorities in request or supervisory authorities mandate is not done, it may go on from a fine to a reprimand to a ban on processing. So it is good to stay on the right side of the supervisory authority, and therefore this request have to be managed properly. Yeah, so this concludes the presentation. I've tried to give an overview of how the request would work in an environment from both the controller and processor, more from a practical standpoint, but this may at some point of time seem academic in nature, because of the India scenario is not the law is not I would say rigid or enforced well, as far as these two rights are concerned, access and disputes, which are both available under the India IT rules in terms of reasonable security practices are there. But I don't think they're enforced much. So maybe most organizations would not receive too many requests, but still, this is important to note. Yeah, thank you.
Thank you.